He wouldn't be here. If you would for us.
You can head in the courtroom then. So over here, ma'am.
Oh, we're gonna do two. Oh, I should have said two. Oh, yeah.
And then I think somebody's gonna have a seat by the other.
We're ready, Judge.
All right, Philomena, if you want to call the case.
I can call it for you, sir.
All right.
Logring and Acre versus Morrison County Sheriff's Department.
Good afternoon, everybody. This is court file 49 CV 221136. Do I have Michael David, is it pronounced Logering, present in my courtroom?
Logering, Judge.
Logering?
Yes, ma'am.
All right, thank you, sir. And do I also have Wendy Ann Acker?
Yes.
All right. And then I also have somebody else sitting at council table. Council, can I have you note for your appearance?
Yes, Your Honor. Julia Kelly on behalf of Morrison County.
And Julia, how do you spell your last name, please?
Kelly, ma'am.
All right, thank you, and you may be seated. First of all, I want to tell you all, I don't know if it was Judge Weiler or Judge Wetzel who issued an order, and I know in Morrison County that they do everything in person. I am chambered in Stearns County, and I like to embrace technology when it is available. So going forward, I'm going to vacate the prior order that says all hearings have to be in person, and if the parties want to appear via remote, I will typically follow policy 525 of the Minnesota Judicial Branch. That policy says that most of the hearings are to be conducted by remote, with the exception of when we are taking live testimony, so that way there can be cross-examination and evaluation of credibility. I will tell you, if we are going to have an in-person hearing, I'm going to hop in my car, I'm going to fly up Highway 10, driving the speed limit, and I will be there with you in person as well. I think that's very important. Okay, so today we're set on for a scheduling conference. And procedurally, this case has been a little bit of a challenge according to the rules of procedure. I do know Mr. Leggering?
Low green.
Low green. Low green. And so it's two syllables.
I don't know, I'm not a speller.
Yes.
Okay.
Excuse me,
so,
Judge,
go ahead.
could I just make a comment to the last thing that we were talking about with the remote hearings?
Absolutely.
The last few remote hearings that we had, the judge hung up on us, and we were not able to give our full account of our statements. They hung up on us, and they ended the hearings abruptly.
So
we would like to ask that if we do remote hearings with you, that you will be respectful of us and hear us in the full amount that we have to say, and we will not be hung up on. If we can be assured of that, we would be okay with remote hearings.
Otherwise, we disagree with remote hearings and we're uncomfortable.
We'd like to be fully heard.
Okay, well, and let me tell you, you have a right to be heard at the appropriate time. So you don't have a constitutional right to spend 4 hours at some type of a scheduling conference type of hearing.
Understood.
So that's why, if you anticipate the hearing is going to take longer, I will be respectful of that time frame, but I also have to be respectful of other cases on my docket, and we will try to allocate the appropriate amount of time, okay?
Okay, however, by law, you know, it takes as long as it takes, Judge.
Well, no, it doesn't take as long as it takes, because there is Rule 403 of the Minnesota Rules of Evidence that says if something is time-consuming and it's irrelevant and confusing of the issues, I'm not going to permit that. I'll allow people to file all legal documents that they want, but if it's not going to be relevant to the case, then no, there is not that constitutional right. Ms. Acker, you had your hand up. Was there some question you had?
There is an attorney, a past attorney in the
Yeah, why is he
hallway right
staring at
now,
us?
and the door is open. Could we please have
Can you
that
close the door?
shut? Because
He
we
has
have-
ill purposes and intent towards us.
He was an
Okay.
attorney for my criminal case that is involved in
Your Honor,
this.
I'm in the courtroom. Is this a closed hearing or is it an open hearing?
It is not a closed hearing. The courtroom
Okay.
remains open at all times.
Well,
Anybody in the public is
I don't feel
welcome to
safe
come
with him
in
standing
and
there.
sit.
I don't feel
Okay.
comfortable.
Okay.
Well,
Excuse
It's
me,
gonna
can
stay
I ask
open.
everybody to please speak one at a time? I'm having trouble differentiating who's speaking.
Ask him to leave.
no, no, no.
He can, so.
Mr. Logreen,
Okay.
you don't get to ask anybody to leave. My courtroom is open and it's open all the time. If somebody wants to come into the courtroom and sit in the galley right behind you,
Okay.
that is what a public hearing is about.
Even the media?
Everybody,
Even the
Okay.
media?
yes.
Thank you,
Okay.
Judge. Can you explain time sensitivity to me? I'm not sure if I quite understand that.
I didn't bring up time
No,
sensitivity.
I know, but can you explain it to me, please?
No, I
What is
can't.
your knowledge of that?
No,
It
Okay.
depends on
Mr. Logreen,
Yes, ma'am?
this is a classic example of where people are going on, and that's not the purpose of the hearing today. And so I don't mean to be disrespectful and cut you off, but I am going to be focused on the purpose of the hearing today. Okay? I also cannot give you legal advice. So you normally are not allowed to ask me questions. You will have to do research or retain legal counsel. Now, we were talking about procedurally. There were several motions that were brought by the plaintiffs, and that was brought before there was proper service on the defendants. Then I saw that there was an affidavit of personal service whereby Jason Michael Hively, Hiveley, served the defendant with the notice of motion, the motion, and supporting documents. That was correct, but the summons and the complaint still have not been served. And so it was a little confusing to me why the plaintiffs would have only some of the documents served and not all of the documents served.
Your Honor, if I may.
Yes.
Yes, Your Honor. I think that there is an error in the docket. I believe it's docket number or index number 63 that you're speaking of, the affidavit of service. That was served by Mr. Stephen Lyon, and Jason Hively is one of my co-counsel on this case. And so the affidavit of service says that he served a copy of the notice of motion, affidavit. So I think it's the reverse, Your Honor. I apologize.
Okay, and I am looking at event number 63 in our Mensis.
I think it's just mislabeled as being filed by Mr. Hively.
I have a copy of it right here.
You are correct. Yeah, the service was done by Stephen Lyon. And so it is correct that it was just a misstatement, but I did see that there was personal service.
Yes, Your Honor. Of the documents, yes, Your Honor. Of the documents listed in the affidavit of service.
Right. And so, Mr. Logreen and Ms. Acker, you're still required to serve the complaint and the summons on the defendant.
How?
I can't give you legal advice.
Personally?
So we can-
Yes. That's
Okay.
why I put in my 2 orders that there has to be personal service. Now, after the hearing today, you can speak with Ms. Kelly about whether or not her client would authorize her to accept service of the summons and complaint on their behalf. But that's outside the scope of the hearing today.